Hello and welcome to this webinar on resolving IP and tech disputes outside courts. It's truly an international event, so let's begin by acknowledging the First Nations people in each of the lands in which we meet. We honour their elders past, present and emerging. My name is Marina Yastrabov and I'm the National Convener of the Australian Society for Computers and the Law. We are very pleased to host this event with the World Intellectual Property Organisation and particularly grateful for the support provided by the Australian Government through IP Australia. An American report estimated that the cost of IP litigation is around $1 million in US dollars per year, staggering costs. And the lengthy delays also involved in court processes are prohibitive. So for many, IP litigation is simply out of reach. Take, for example, Daniel Morell, the photographer who sued Getty Images and AFP in 2011 for posting his Twitter photos without authorization, so i.e. a copyright dispute. While he ultimately received judgment in his favor for $1.2 million, it took 5 years to reach that resolution, and it generated a staggering $2.5 million in legal fees and costs. So there's something not quite right about the system. Is alternate dispute resolution part of the solution? And if so, how do you include this option in the contracts that you're negotiating, and can WIPO help with their standard clauses? To me, the answer is certainly a yes. Our speakers today have extensive international IP and technology law and dispute resolution experience, and we're delighted that they'll be presenting today. Leanardo is the head of the Business Development Unit at WIPO in their Arbitration and Mediation Centre. And Leanardo, if you could move to the slides so they can see your lovely description there of your expertise, and as you describe your younger brother. Now, if we could go to the next slide, please, for Charlotte Spencer. She is a qualified barrister and performs a critical role as legal officer within the Internet Dispute Resolution section of WIPO as well. Following presentations from both our speakers, we will open to audience Q&A, so please have your questions coming throughout the session. Leanardo, it's now over to you. Thank you so much for your time.
Thank you very much, Marina. It really is a pleasure to be here with you and with all of you. Hi, Charlotte. Thank you for joining us today in this webinar. We would like to thank AUSCL for the opportunity to bring this topic to your attention, and of course to IP Australia for their collaboration to support this event. The idea today, as Marina mentioned, is to cover alternative dispute resolution. So we'll be talking about mediation, arbitration, and domain name dispute resolution services and mechanisms for intellectual property, and in particular for technology disputes. Now, in this webinar, you will have a chance to also download some handouts. You will find them on your module on the right-hand side of your screen. You can also send your questions through the chat box, and at the end of the presentation we will reply to some of the questions, and for those questions that we cannot cover during the live session, we can reply to them by email. So please feel free to send your questions. I will be very happy to reply to them. Now, the topics that we would like to cover today are why mediation and arbitration can be a good alternative to resolve intellectual property in technology disputes, how to draft efficient dispute resolution clauses for your technology contracts, and how to tackle trademark abuse on the internet through domain name dispute resolution services, and Charlotte will be covering this topic. For those that are not familiar with WIPO, WIPO is the World Intellectual Property Organization. It's a specialized agency of the United Nations system. And the mission of WIPO is to promote innovation and creativity for the economic, social, and cultural development of all countries through a balanced and effective international IP system. So among other activities that WIPO, for example, administers treaties. It, of course, works with countries to develop the IP systems in the different places, and also provides services. So in this sense, we have services that parties can, stakeholders can use to protect their international intellectual property. This would be through the PCT, the Patent Cooperation Treaty, the Madrid system for trademarks, the Hague for designs. But we also provide dispute resolution services, what we call alternative dispute resolution, alternative to core litigation, to reduce the impact of disputes on innovation and creative processes. And we do so through the Arbitration and Mediation Center. So the center was created in 1994, so it's been around for over 25 years now, and we don't resolve the cases ourselves. So WIPO is not the one issuing the decision, but we engage external experts, arbitrators, mediators, panelists, to decide or to help parties to resolve their particular disputes. So we facilitate the resolution of disputes, and we're talking about commercial disputes between private parties. So here we're looking at companies, we're looking at creators, innovators, for example, R&D centers, universities. And these disputes are usually linked somehow to IP and technology. And of course, IP and technology are more and more present in our daily life. So there's an increase in transactions involving intellectual property, and for that there's a potential for the increase of disputes in this area. So WIPO has offices, our headquarters in Geneva, and we also have an office, the Arbitration Center in Singapore. But of course, that doesn't mean that you have to go to Geneva or Singapore to resolve your disputes. Most of these cases are dealt with through online systems. We have an online platform, and we also rely on video conferencing facilities more and more, in particular during this pandemic time. So the users of these services come from all over the world, including from Australia. We have had cases involving Australian parties, most of the times international cases. So an Australian party, perhaps part of a contract with a party in another jurisdiction, and it's been quite useful for Australian parties to use this alternative instead of having to travel, for example, to other jurisdictions. I was mentioning a minute ago about our mediators, arbitrators, and experts, and here we have a list of about 2,000, including from Australia, that are specialized in different areas of IP. So there are trademark lawyers, patent lawyers, entertainment lawyers, IT, software experts that know not only about the legal matters, but also about the industry practices. And this is interesting because many times when you go to the courts, you may not have the chance to have a judge specialized in a specific matter, and these experts can help to have an outcome that is more suitable to the needs of the parties. WIPO also benefits from international neutrality, so this is something that is quite useful when it comes to international cases. When you may not want to go and litigate in a foreign jurisdiction, you may want to avoid the home court advantage, and then this could be a good compromise as a neutral option. And well, WIPO is also the global leader in domain name dispute resolution services, and we will learn more about that later today. Thanking again to IP Australia. This is for your information. We have an ongoing collaboration with IP Australia, and there you will find information on the website on how to use arbitration and mediation for international disputes. So please feel free to visit this website or to send any questions in case you have them. Many of you might be familiar already with these basic principles, mediation, arbitration. We thought would be useful to at least give some basic knowledge and to compare them to see whether, you know, it depends so much on your strategy when you are resolving a dispute, whether you want a settlement, a compromise, or if you need a decision. So it's important to know the differences. First of all, both are mediation and arbitration are consensual, voluntary. So that means that you need to agree with the other party or with all other parties to use arbitration or mediation to refer a dispute to ADR. This is a difference with court proceedings when you just go to the jurisdiction and you start your case. So we cannot force anyone to use arbitration. The way to agree is by, for example, including a clause in a contract. So any future dispute will be resolved by mediation or arbitration. Mediation is more informal. So here we have a neutral intermediary, the mediator, that will be helping the parties to try to reach what we call a win-win solution, so a compromise. In the mediation, the mediator won't be able to impose any decision. It might be able to evaluate. So if the parties ask the mediator to make an assessment, it might give an opinion on the case, but that doesn't mean that this is binding. And it's mainly based on parties' business interests. So not so much about the legal provisions. Of course, they are relevant, but it's more about finding a commercial solution. If the parties reach an agreement, then this agreement will be a contract, and if there's any issue, then it will have to be enforced as any other contract. Now we just from September we have the Singapore Convention on Mediation that will help to enforce these agreements internationally. So now only a number of countries have ratified the convention. There are over 50 that have signed the convention. So in the future, we will have this international instrument to make it easier to enforce the results of a mediation internationally. This is very good news for the development of mediation. And of course, in mediation, if you're not happy with the process, you can step out of the mediation and then you can move on to a more formal procedure. This could be court proceedings, or it could be arbitration. So in that sense, it's quite flexible. So it's worth trying most of the times. Of course, it depends on the case, on the problem, but it's a very flexible tool. Arbitration will be more like the, if you want an equivalent to a private court. So the parties here are looking for a decision maker, are looking for a decision, and that this decision will be binding and final. This is very important to keep in mind. Binding because once you agree to use arbitration, then you also agree to comply with whatever the arbitrator decides. And it's final because there's typically no appeal stage. If you go to the courts, you'll have to go through a few instances, so that will take time. Of course, it will also give you a chance, if you don't prevail in the first instance, to have a second chance, while in arbitration, this decision will be final. There are no, as I was saying, appeals, so the parties could agree to have a second instance. It doesn't happen often, at least in our experience. And with that, then it makes the process more expedited too. Typically, the arbitration is based on parties' rights and obligations, and it's the result, which is called award, it's enforceable internationally. This is a very important advantage of using arbitration for international disputes. There's a convention. We talk about the Singapore Convention. Now we'll name the New York Convention, that is from 1958, and it has 165 member states, including Australia. That means that if you have a decision issued by an arbitrator and the other party does not comply, you could enforce that through the courts of that jurisdiction without having to prove everything again. So it will be enforced as if it was a judgment from that court. So that's a very expedited way to enforce the arbitration awards. And it normally forecloses core options. This means that once you agree to use arbitration, then you can all unilaterally just say, you know what, I'm going to go to the courts. I'm not happy with using arbitration, and you go to the courts, and the courts have an obligation to send you back to arbitration if they're a member of this New York Convention. So that's a safeguard. That's a very useful provision to keep, that once you commit to use arbitration, then unless you agree with the other party, then you will have to stick to the arbitration. So these are some useful pointers to keep in mind when we talk about mediation and arbitration. Sometimes people tend to confuse them or to use them in a mixed way. Some years ago, we conducted at the Arbitration Center a survey on technology transactions. So this was mainly related to patents, know-how, trade secrets, software. And one of the questions that we asked was, what are your main considerations when you are drafting a clause in your technology contracts when it comes to a dispute resolution choice? And here there are no surprises. We can see that both for international and domestic contracts, time and cost, or cost and time in this case, are the main priorities. Then we look at the enforceability, and this is of course more relevant in international disputes or international contracts, to make sure that you have a mechanism that could be, once you have a result, that result can be easily enforced. And this is when we're talking just about arbitration awards. The quality of the outcome also very important. If we look at IP technology, we know that sometimes the topics or the contracts can be quite specific, quite sophisticated. So you need a very specific knowledge sometimes, and that's why you need to have an expert. And in arbitration and mediation, you can appoint an external expert to decide a case. The neutrality, we talked about that earlier today already, especially in international disputes. And confidentiality, if we think, for example, of R&D, like research and development collaborations, and the importance of confidentiality. If we face a dispute, we need to go to the courts. Maybe the record becomes public, because in many instances they are public, and this can affect even trade secrets or other IP rights. We also ask in that survey, what is your experience in terms of using arbitration and mediation and the courts for IP and technology disputes? And here we can see that when the respondents of the survey use the courts in a foreign jurisdiction, they found that it was more costly, and it took more time than when doing it at home, and even more than when using arbitration, expedited arbitration, or mediation, or expert termination. So again, that's the experience of all these respondents. It shows that a well-managed arbitration and mediation can be faster and less expensive than using the courts. And of course, this depends a lot on the jurisdiction, on whether the courts are specialized or not, but it's just to give you an idea of trends that we observe. More recently, Queen Mary, University of London, they have the School of International Arbitration. It's a very prestigious institution that every other year conducts an international survey on dispute resolution. And a few years ago, they focused on media, technology, and telecoms, what we call TMT, including intellectual property. And here, perhaps, this was conducted, this survey among companies, some 400 companies from around the world. We can see that the majority of these companies, they indicated that they have a dispute resolution policy. So this is a very healthy practice to anticipate, to be prepared for disputes, to decide whether, if you are entering into a contract with a party in a certain jurisdiction, if for that you will have a court clause or an arbitration or a mediation clause. And within this policy, mediation is the most encouraged mechanism, followed by arbitration. So we can see an increased use in the technology and IT sectors of ADR. And when using arbitration, the most important elements are the institution that will help with the case, the seat, that means the place of the arbitration, and the confidentiality provisions. Now, again, the vast majority responded that arbitration is well suited for technology disputes, and they also foresee an increase in the use of arbitration, and that ownership of IP and licensing of technology, including data breaches, for example, and security breaches, are going to be a source of dispute, going to continue being a source of dispute. That's something that we might consider quite obvious, but it's interesting to see reflected in the practical experience of stakeholders. Now we talk about the differences and similarities of arbitration and mediation. It's usually quite useful to see in a nutshell some considerations, whether this depends so much on your strategy. Sometimes you will need a public decision, you will need to enforce your rights and to get a decision from a court. So then going to the courts will be perhaps more suitable for you than using arbitration or mediation. So it depends again on your preferences. And of course, we say arbitration mediation are voluntary, so that's the first entry barrier. If you want the specialization, the whether the neutral will make a decision or not, confidentiality, if it's sufficient for international disputes, whether you can tailor the procedure. That's another interesting advantage of both mediation and arbitration. We have seen cases where the parties needed to have a decision issue fairly quickly in a couple of months, and that's something that you may not be able to get in the courts. So it's very easy to adapt to the needs. Possibility of appeal, and we covered that, and the international enforcement of the outcome. And here the courts, this enforcement might be more limited and subject to agreements between jurisdictions. We here at WIPO, we have a set of rules, so it's just more to make you familiar with what rules are in general for arbitration and mediation. This is a framework that again is can be tailored by the parties. In the WIPO rules, you will find some provisions that might be interesting for you if you're dealing with technology disputes. And this is, for example, confidentiality provisions. So once you agree in your clause that if there's any dispute in the future with the other party, you will use the WIPO arbitration rules, then you're incorporating these rules to your agreement with the other party. So if you don't agree on procedural matters, because maybe you are already involved in a dispute and there's no good dialogue, good chance to discuss things with the other party, then the rules will apply. And if you cannot agree on how to appoint the arbitrator, for example, there's a default procedure. There are confidentiality provisions, so that they will cover the existence of the arbitration, the content or the mediation, the content of the whole process, and the outcome. And this is an obligation that extends to not only the parties but also the mediators, arbitrators, and of course WIPO. So that's why when I'll present some cases and I won't be able to tell you who the parties were or who the arbitrator appointed for the case was, because of confidentiality provisions. These rules can be used for domestic and international disputes. In our case, we see about 75% of the cases have some international component. That means that the parties are in different jurisdictions. It could also be that there are rights protected in different jurisdictions, and they can accommodate different legal traditions. So in an arbitration, you will find a combination. You are in a common law jurisdiction, but you will let's say that you have a dispute with a company that comes from a civil law system, and you will have a combination of these procedures. You can tailor it in accordance to whatever the parties think suitable for that particular case. How can you use arbitration or mediation? We say already that these are consensual mechanisms, so there are a few ways. The most common way would be to include a clause in your contract, and we will check the main elements of model clauses. But what if you don't have a contract with the other party? If you're in an infringement situation, if the other party, or if there's a contract and there's a different clause, still at that stage, you can agree with the other party or parties to refer the matter to mediation or arbitration. This, of course, can be more challenging because you are already involved in a dispute, but it's something that we see happening more and more. And this is linked to the next bullet point, the unilateral request for WIPO mediation. And of course, we talk about mediation being consensual. This is just an invitation to another party to consider mediation. That's a fairly new development that we included in our rules, and we're seeing very interesting developments, because it's a possibility that, for example, an inventor, a creator can have to invite the other party to consider mediation before going to the courts or to whatever dispute resolution option that was in their contract. And of course, the other party can not even acknowledge this, or may say I'm not interested, and there's no way to force the other party. But it's a record that we showing goodwill to try to resolve the dispute in an amicable way without let's say fighting in the courts, or and this could be also used as a record if you go to the courts to show that you try. And in some jurisdictions we also see this more and more in legislation. There might be some fines, or the way that the cost of the court proceedings are apportioned can be affected by this if you didn't even acknowledge that. So it's another option, as I say, it's something to keep in mind. And then we also see an increase cases coming from the court. So the judges are more and more familiar, of course, with particular mediation. There are schemes in some jurisdictions where you have to go through a mediation phase before starting court proceedings, or in some other instances, the judges might suggest parties to suspend the case and maybe try mediation for, let's say, 1 month, 2 months, or the parties may ask the judges to suspend the case to try mediation. That's something that we have seen. It's another trend that we observe. Now, moving into a few details for the model clauses. Here you can find these model clauses on our website, so the different combinations of mediation followed by arbitration, and that's the clause that we're going to be analyzing today. It's what we call multi-tier or escalation clause, where you first have a mediation phase. So you try to resolve the dispute through mediation, and if that cannot be achieved in a certain period of time, it could be 60 days, 90 days, for example, then you move to the arbitration. Now here, very quickly, we can see at the beginning, there's a long list of words. It talks about any dispute, controversy, etc., etc. So the scope is quite broad. That's the intention. So sometimes the recommendation in a way would be to not touch too much model clauses, but only tailor the elements that need to be tailored to avoid any issues with the validity of the clause, or any issue that the scope may not be broad enough. There's a reference to the WIPO mediation rules in this example of a WIPO clause. So that means that then WIPO could administer the case. You can fix the place of mediation. Now, more and more, especially now during the pandemic, we can see these cases, they take place online. Of course, you know, there are different considerations. Sometimes you may think that all the parties and the mediator being in the same room, you know, the body language issues and other matters that might be relevant. And perhaps if you do it online, this could be perceived differently. We're seeing that parties are getting more used to doing these mediations through online means. You could also fix the language of the mediation. And then in the second one, it's very important to include this period of time, because that will allow you to move from the informal mediation phase to a formal arbitration phase. If you say 60 days and the other party is not cooperating in good faith and wants to keep the mediation open, for example, then you may have issues to pass to the arbitration. And as we said before, once you are in the arbitration, that's it. You cannot just step out. If you don't participate, you'll be declared in default. So it's also a way to have some pressure on trying to resolve the case through the mediation phase, if possible. Then in the arbitration, there are a few important elements. And here, perhaps you have the place of arbitration, or what we call the seat of the arbitration. That is not necessarily the physical location of the arbitration, but it has a legal connection with the jurisdiction. And in some instances, you may need to get assistance from the local courts to help with some, for example, collection of evidence in a case. The place of arbitration will also determine the nationality of the award. Remember, we talk about the New York Convention. So if you say Sydney, Australia, then the award will be an Australian award. Australia is part of the New York Convention. Then you can enforce internationally through New York Convention. So you need to do your due diligence before including the place to make sure that it's an arbitration-friendly place. And then if you need any help from the court, they will understand what happens in an arbitration. Also, another important element of the clause is the applicable law. In most of the cases, the law will be the same law as the law applicable to the contract, but the parties may include some other provisions. So you can find more information. We have also an online clause generator that you can see here on the screen. And there you can go through and you can build your clause. You can learn more about the different elements. And if you have any questions, if you're negotiating a clause, you can always contact us and we can explain the different elements. Of course, we cannot provide legal advice, but we can provide procedural advice. So feel free to contact us. Some pointers to close the clauses section. What we see is an increase in the use of mediation. So you can have this combined clause. More than 40% of the cases that we see have a mediation followed by arbitration clause. In mediation, we will see settlement rates later, and you will find it perhaps interesting. If you go for arbitration, we also have an expedited arbitration version. So sometimes, and we see this very much in the IT sector, in the software area. Then if you have an institution or not, that will help with the administration of the case. The institution will help you with all the logistics. So you may have perhaps to pay a fee to an institution, but then you won't have to deal with all the logistics. And again, use model clauses, perhaps just not tailoring it too much to avoid bigger issues. Now, in terms of cases, I'm gonna cover some case examples, and then we'll move to the domain name part of this webinar. You can see here that it's fairly distributed in terms of the different type of IP or type of cases, patents in ICT. If we put them together, we get there almost 50% of cases at WIPO are related to technology. And this, of course, includes, as I was saying, patents and trade secrets and software and other infrastructure. In terms of settlement rates, we have a 70% settlement rate in mediation. So that's 7 out of 10 cases settled. That's pretty high. And in arbitration, we remember that in arbitration we want a decision. So maybe settlement is not the main objective, but still in more than 30% of the cases, we've seen the parties settling. And in some cases, you have parties first attempting mediation, and maybe in the mediation they don't have all the elements, they don't feel fully comfortable to settle, and then they move to arbitration, and after filing the pleadings or seeing some evidence and realizing maybe that it's better to settle, then they reach a settlement. So that's why we always say try mediation before, in case you can settle or narrow down the dispute at least. Some case examples, again, these are anonymous, but at least to give you an idea of the type of disputes, we can see a mediation related to a mobile app dispute between startups in the Middle East and in the US. Here we are looking at a licensing agreement for mobile phone applications. And there was a clause in the contract, mediation followed by WIPO arbitration. And the issue was related to whether the use of the application in the license was made against a payment or free of charge. The parties, they're small companies, so they couldn't allocate big funds to have a case, for example, to travel and to meet somewhere. So they decided to use online facilities to meet with the mediator, and they had plenary sessions, and they also had private meetings with the mediator. And within 2 months, they managed to resolve the dispute. And what is interesting in mediation is with the objective of continuing working together, continuing collaborating. The second example is an expedited arbitration of a software dispute. Here we have also quite small companies, SMEs, developer in the US and European company. And this is a licensing agreement that was concluded online, permitting the use of a security software for the distribution through the internet of the software. And here the parties had an expedited arbitration clause, so they didn't have a mediation phase, so they went straight to the arbitration. They work together for some time. That's another thing that we observe, that in many cases the parties work together for a period of time, and then they face a dispute after a few years. We recently had a case, licensing agreement for 20 years, and the dispute happened in the year 17. So you had a long collaboration, then there's a dispute, and you may want to resolve the dispute to continue working together. So in this case, there's a breach of contract, and the case, the sums were quite substantial. The parties could not agree on an arbitrator, and they asked WIPO for the recommendation. So we usually send a list of 3 to 5 candidates matching all the requirements, and the parties make a ranking, and that's how they appoint the arbitrator. And there was a hearing that in this case was also conducted online, and the arbitrator then render the final award. Another 2 examples is settlement of a software dispute, and here we have an Asian company and a European software development. This is to provide mobile payment services in Asia, and the clause here was WIPO arbitration. There's a breach of the contract. The Asian company initiates proceedings, and both parties, as quite heavy proceedings, the parties request the interim measures within the arbitration and with the courts. So it was getting quite tangled, let's say. And then the arbitrator review all the pleadings, all the measures, all the evidence. He proposed a conciliation conference, so before rendering the award. And then the parties consider they continue negotiating, and they settle the dispute. So there was no need to issue an award where you get, one wins and the other one loses. So the European developer agreed to pay a certain amount of money, and the Asian company to transfer the IP rights. What usually happens in these situations is that the parties request the arbitrator to issue a consent award. So you will have an award reflecting that the parties reach an agreement, and if there's any, why do they do this? Because if there's any party not complying with the agreement, then you can enforce the award internationally. So it's also it comes within the WIPO arbitration rules. You will find an article. The arbitrator can assist the parties and can promote settlement. And if they reach a settlement, it can be recorded as an award. That's a practice that we also see often. And just a last example here to show new developments, for example, in the fintech industry, cases are starting to land some disputes, in this case related to the manufacturing of personal identification cards and software. So that's another example in this area. And I think that's my final slide, would be a brief case study where we wanted to show you the dispute resolution policy of a group of software companies based in the US, that they use WIPO mediation and arbitration. Here we're analyzing 25 cases. These cases were all related to software agreements, most of them licensing agreements, maintenance agreements, reseller and distribution agreements. And the dispute resolution policy is to include in their terms and conditions for B2B agreements, that's when they provide services to other companies, to include a mediation followed by expedited arbitration clause. What we have seen in these cases is that more than 50% of the cases were settled after one of the companies from this group initiated. They're mostly related to lack of payment of licensing fees. Some of them are quite large, some of them are quite small. So there's a wide range. As a group of 60 companies, so there's a wide range of disputes. And we say like more than 50% of the cases were settled after starting mediation proceedings, and many of them were settled even after the mediator was appointed. So the sole fact that the company initiated mediation triggered the dialogue with the other party, and the other party decided to pay, and the mediation was terminated. So that was very time and cost efficient for the company. In only a very few number of cases after the mediation phase, the company started expedited arbitration. And these are mainly in cases where the amounts in dispute were quite large. But this suggests that in many of the instances, the parties might have reached an agreement before commencing the expedited arbitration. And the average duration of these mediation proceedings was 3 months, so it's fairly quick. And many of these cases were between US companies and foreign companies, but some of them were also between the US companies, two US companies. So still, for national disputes, they chose to use mediation. I think with this, I'm gonna pass it to Charlotte. So of course, very happy to reply to any questions at the end of the session or by email. The idea was to give you a snapshot of the different trends and things that we observe when dealing with technology disputes. Charlotte, over to you.
Thank you, Leandro, and good evening, everybody. I'm here to share WIPO domain name dispute resolution experience. I've been working at the internet section for over 10 years, so I'm very happy to be here to share our experience. So of course, we are all using internet every day, even more today. Businesses and consumers are heavily relying on the internet. And we shop online, we try to find for information with the internet, we even work from home, and so we are using domain names every day. But we've seen more and more trademark abuse with the internet. What kind of trademark abuse we're talking about? Well, for example, if your company finds out that there's a website referring to your brand or your company with links to competitors, or if you found out about a website with counterfeit products, or if you find out that someone has registered a domain name and is willing, with your brand, and is willing to sell it to you for a very high price, or otherwise someone who's using a domain name to send fraudulent emails. And so to tackle those trademark abuse, WIPO has created 20 years ago the UDRP, the Uniform Domain Name Dispute Resolution Policy. This is an administrative procedure, so this is it's different from the arbitration and the mediation procedures, because it always preserves the court options after the UDRP proceeding. And this proceeding has been put in place only for very clear-cut cases of trademark abuse. So for more complex cases of trademark abuse, of course, it might be recommended to file a court option. The UDRP has been, so as I said, it has been created 20 years ago. It has been a very successful tool for trademark owners. It has been used for a lot of companies around the world. It's a very international procedure, including Australia. And one of the aspects that has made that procedure very successful is that the decisions that are made by experts, so as mentioned by Leo, WIPO is not making any decision here. We are appointing experts which are making decisions, and those decisions are implemented by registrars. And the only remedy that you can ask when you file a UDRP case, you can ask either for the transfer or the cancellation of a domain name. So you might not ask for any money damages, so that would be more with a court option. It's really only to get your domain name back or to cancel the domain name. And the UDRP is applicable for all the GTLDs. So we're talking about generic top-level domain name, such as .com, .net, .org, but also all the new GTLDs. As we know, a couple of years ago, we have, in addition to the GTLDs, we have new GTLDs such as .paris, .love, any generic names. And also many CCTLDs have adopted the UDRP, and we will talk briefly about the .AU procedure. On the next slide, so why would brand owners choose to file a UDRP complaint instead of filing a court option? Well, as I said, it's always an option, but typically the UDRP procedure is significantly quicker. It's a procedure that would only last 2 months. and it's also typically cheaper than the court litigation. A UDRP procedure will cost $1,500 US. Another reason why brand owners would use the UDRP is that you have a predictable criteria and result. And that is very important. We have put in place what we call an overview, which is a document that I will briefly present it to you, where we have put all the scenarios. And so you know if whenever you will file a UDRP case, whether or not you have a chance to get your domain name transferred or not. The other reason is, as I already mentioned briefly, is that it's very efficient because the decision that is made by the expert will be implemented directly by the registrar. The registrar is the entity with which someone registers a domain name. So you don't need to go to court again, and just after the WIPO's decision, within 2 months, you get your decision and the registrar will transfer the domain name. So it has been said by brand owners that that was one of the main reasons, that it was very, very efficient to get that decision so quickly and transferred by the registrar. So as was mentioned by Leo previously, WIPO has been a provider for over 20 years and is today the leader provider for domain name disputes. We have covered 48,000 cases so far, covering 85,000 domain names. Each we have more and more complaints, and last year again in 2019 it was a record year when we receive and we administer over 3,000 cases. It's not necessarily a good sign. It means that cyber squatting is still here, but it means that companies are very happy with the UDRP and they find this procedure very efficient. So we can see the top 5 filers of last year. Philip Morris was the first one, followed by Facebook, Sanofi, the pharmaceutical company, Carrefour, this French retail company, and then Accenture and Lego at the same position. On the next slide, you can see that this UDRP procedure has been used by all the countries, involving 122 countries around the world. We administer this procedure in many, many languages, including Chinese. Recently, we have a lot of Chinese and Russian cases, and we have case managers that are coming from around the world and could administer cases in many languages. The language of a UDRP complaint shall be the language of the registration agreement. So this is why we have to follow, the UDRP has to be in the language of the registration agreement. It is a paperless procedure, so everything is online. So as we've seen recently with some of the tribunals who were closed, we continue our business as usual. This is an online procedure, and we receive the complaints online, we receive the response online, and the decision is issued online. Who are using mainly our services? The US is the country using the UDRP procedure, but it's followed by a lot of European countries such as France and the UK. On the next slide, we can briefly, this is a slide to show you briefly how to file a UDRP complaint. So it's very simple. You just need to file a complaint and the annexes, which is electronically. You don't need to have a lawyer, and you just have to fill out the form. The only thing is, of course, you have to meet the 3 criteria that I will mention briefly to file this UDRP complaint. But we have model complaints that are available in many languages. And as I said, everything is online, and you don't need a lawyer. On the next slide, this is a tool that can be very, very important if you do decide to file a UDRP complaint. This is our overview. So this is a selection of all the decisions that WIPO, all the experts have rendered, and in like a lot of procedural issues regarding the UDRP. So what kind of trademark are protected under the UDRP? What do you mean by bad faith, for example? Or in which language should I file my UDRP complaint? So with this overview, you can really find all the information, all the previous decisions that have been rendered in a specific issue. This is an online, this is available online, and I think this is one of the handouts that will be given to you after the presentation. It's also because all the decisions are published, all the decisions rendered by the experts under the UDRP are published, so you can always find those decisions online. In addition to the overview, you also have this legal index. So the legal index is more if you're using it using keywords, if you're looking for more information or for a specific case regarding, I don't know, if you have a counterfeit situation or if you have a fraudulent email situation, you just type your keywords and then you can find relevant decisions that have been rendered under the UDRP. So those are two useful tools whenever you decide to file a UDRP complaint. As I said, it's not mandatory to have a lawyer, so you can use those tools. In the next class, yes. So how a UDRP case is decided. So as I said, it's pretty simple, but there are still 3 criteria which are mandatory to file a case. The first one is that you have to have a trademark. The UDRP procedure is mainly only for trademark owners. It can be a trademark that is registered or a common law trademark, but you need to have, you have to show that you have a trademark. That trademark can be registered anywhere in the world, but we need to have a trademark. And then you need to show that the domain name is identical or confusingly similar to that trademark. That first criteria is typically quite easy to prove if you have a trademark. As long as the trademark is, you recognize the trademark in the domain name, then it should be quite easy to set up the first element. The second element you have to show is that the domain name registrant has no rights or legitimate interest in the domain name. A registrant would have a right or legitimate interest in a domain name if, for example, that person will be commonly known by the domain name, or if that person would be using that domain name in a bona fide way of selling goods and services. And finally, the third element that you need to prove is that the domain name has been registered and is being used in bad faith. So for the bad faith registration, typically if your trademark has been registered before the domain name, it will be quite easy to show that the domain name was registered in bad faith. And for the bad faith use, this is what we've mentioned already. Selling, competing products on a website or counterfeit, or even using your disputed domain name for fraudulent emails, that would be bad faith use. And it even has been recognized that the fact of not using the domain name can also be an evidence of bad faith use. On the next slide, so those are the 3 criteria to file your UDRP complaint. We thought it would be interesting just to share with you with this special year that we had on the COVID, what was the impact of COVID on domain name cases? Well, we've seen more domain name registration, and then we've seen more cases involving cyber squatting and COVID. So we've received, as of March, we've seen at WIPO, at least, we've been receiving more and more cases related to the COVID, and some companies have been filing cases either related to pharmaceutical products, for example, such as SanofiVaccine.com, but also related to the internet and IT. Facebook have been filing a lot of cases where their trademark was registered together with COVID, but also in the banking and finance sector, we've been seeing more and more cases. Since March, yes, we've been receiving 100 cases where trademarks and COVID were registered together. On the next slide, yes, so we thought, of course, this is all the UDRP, this is all regarding the UDRP, and I'm happy to give you, of course, more information about the UDRP procedure and reply to any questions. But we thought it would be interesting, because of the Australian audience, to share that we are also a provider for .au domain names disputes, so Australia disputes. And we've been working since 2003 with AUDA, the .au registry, so the entity that is in charge of the .au CCTLD for Australia. And WIPO is a provider, and so we administer cases the same way we administer cases under the UDRP. But .AU has adopted a policy which is slightly different from the UDRP. There are a lot of similarities, but there are also some differences. And so far, since 2003, we've administered nearly 500 .AU cases. And this year, we have received 23 cases. We worked together with AUDA for many years, and we tried to update their policies and try to make sure that Australian companies are using this service. On the next slide, you can see our statistics. So since 2003, we're a provider, and as you can see, we since 2011, we've been receiving an average of 40 cases per year, which is a good number for, we are also a provider for other CCTLDs, and an average of 40 cases is a good number. So it means that parties are happy with that service. It can be either people from Australia, but also people outside of Australia. This is our dedicated web page about .AU. So this is all the information you can find about the .AU. So the link, of course, to AUDA, the .AU registry, but also if you're looking of who's the domain name holder of the domain of the disputed domain name. So you have what we call the who is, and then what is the mechanism that AUDA has adopted. So here, as we said, it's a variation of the UDRP. Are some differences between the UDRP that I'm covered in the next slides. But you can find also information about the eligibility criteria or any other kind of information. So what are the main differences between the UDRP and the .AU policy? Well, first, the rights that are covered. As I briefly mentioned for the UDRP is only meant to be for trademark owners. So you need to have a trademark. Well, under the .AU policy, you only need to show that you have a name protected under Australia. So that can be a trademark, but that can be also a company name, or that can be a common law trademark, and in some situation, it can even be a family name. If you do remember, the third criteria under the UDRP was bad faith registration and use. Well, under the .AU policy, it is only sufficient to prove either the bad faith registration or the bad faith use. There are some eligibility criteria for .AU. So if you're asking for the transfer of the domain name, you have to make sure that you have a link with Australia in order to register the .AU domain name. The fees are also different. I mentioned under the UDRP, it's a $1,500 US. For the .AU policy, it's 2,000 Australian dollars. And the list of panelists, of course, is different because for .AU, well, we have a specific list of panelists who are coming from Australia and who are able to render a decision making reference to the .AU policy, but having an Australian background on trademark law or internet and so on. We thought it would be interesting just to show you some of examples, some of the cases that we received last year and this year. So as you can see, we have big brands who are using our services, such as Airbnb or Amazon, but it doesn't mean that the AU policies are only meant for big companies. .AU policy is the same. You don't need to have a lawyer to file a complaint, and it's also small and medium enterprise are also using this service to make sure they can get their domain name back. As we all know, today it's so important to have your business online that really people try to get their domain name back when they can. So this is a brief introduction to the domain name services of WIPO. I'm of course happy to reply to any of your questions regarding the UDRP or the .AU policy. As I mentioned, I think you will have the overview in your handouts and also a guide about CCTLDs, so that will give you also more information about .AU. And please feel free to send us any questions via email, and I think maybe we'll still have time to reply to some of your questions. Thank you.
Thank you, Charlotte. That was very informative, very practical too. So we hope you find this useful. These are tools that we wanted to present to you, so you're aware that they exist, and the basic steps to use them, and basic concepts. Of course, there's a lot more that we can say about domain names, arbitration, mediation. We're always happy to engage. If you have any questions, you can contact us. We can speak on the phone, of course. We have a LinkedIn account, newsletters, other webinars if you're interested in knowing more about this subject. I was checking the questions. I saw there were some questions that I think were covered, because the questions came before we covered the topic. So there are a few that are already reply, in my view. Charlotte, maybe I have one that could be interesting to highlight. You mentioned that you've been working at WIPO for a decade, so you know very well all the trends and different things that are happening. And the question that we received was whether the cyber squatters are getting more sophisticated. And if you can share with us a few examples or some brief information on that.
Yes, that's a very good question. We could talk an hour about this, but briefly, I think yes, definitely cyber squatters are getting more and more sophisticated. When the UDRP was created 20 years ago, it was really, and as you see, the UDRP itself gives example of really like someone buying a domain name and trying to sell it back to the brand owners. But now we're talking about people who are registering domain names. It's not manually anymore. Everything is automatic. They've been using privacy service to hide their identity. With the GDPR, it's even getting bigger. People are really trying to hide their identity while they're selling or they're registering domain names. We've been seeing also a lot of like fraudulent emails and identity theft. So yes, it's actually, I mean, it makes it interesting because of course we have new challenges to deal with every year. But yes, cyber squatters are definitely, I just like following the trend and making sure that they're able to register domain names that are valuable, and this is a bit unfortunate, but we've seen it again with the COVID situation. You know, that there are, with this situation, while cyber squatters have been registering domain names in relation to COVID, and brand owners have been trying to tackle this situation. Yeah.
Okay, well, thank you very much for that. I think we are a little bit over 1 hour now. If there are any other questions, we're happy to reply by email. So thank you very much for attending this webinar. Marina, we wanted to thank you in particular for coordinating and for helping us to organize this event. It's been really a pleasure, and we hope you find this information useful. Again, we are available for any questions. You can contact us. You have our contact details now, and I think that's all for today. Thank you very much.
Thank you very much, Leo. Thank you, Marina, and have a good evening, everybody. Then I guess we'll have a long day.
Starting the day.
Yeah. Thank you, Marina.